itself. Who better to walk us through it than our Trump legal trouble all-stars? Mike Davis, founder and president of the Article 3 Project, and Dave Ehrenberg, state attorney for Palm Beach County, Florida, where Mar-a-Lago is located. You can find Mike on Fox News and Dave on MSNBC, but only together here on this show. Mike and Dave, welcome back.
Thank you for having us.
Great to be back. Yeah, Happy New Year, Megyn.
Thank you. I apologize for putting that song into your heads. It's so damn catchy, but you do at least learn something. Okay, so Trump is appealing to SCOTUS, the Colorado ruling. He's also filed his appeal of what the Maine Secretary of State did. That's got to play out in the Maine state courts first. But really, the Supreme Court will have the final say on whether an administrator or a judge can kick a presidential candidate off of a ballot by declaring, either by a, guys in robes, or in this case, an unelected Secretary of State who's not even a lawyer, that he's an insurrectionist. The Supreme Court will have the final say, and we think that they're going to take the immunity case. Well, we'll get to the immunity case, sorry. We think they're going to take the case about whether he's an insurrectionist and can be kicked off the ballot. The question is when and how will they rule? So, Mike, what's your prediction on what the Supreme Court's likely to do on these rulings out of Colorado and Maine?
So I think the Supreme Court will take this case and take this case quickly, even though these cases are stayed by the Colorado Supreme Court. Once Trump filed his appeal, the Colorado Supreme Court said we're going to stay the decision and go ahead and put him on the primary ballot. Same in Maine. The reason the Supreme Court needs to take this case is because this bad precedent in Colorado with the four wacky Democrat-appointed Supreme Court justices and this 4-3 ruling in this, like you said, unelected, non-lawyer, wacky Maine Democrat Secretary of State who thinks that they just get to decide for millions of voters who's on the primary ballot. That is a terrible precedent, and that needs to be nipped in the bud immediately so it doesn't get used in other states. If the only way you can disqualify under Section 3 of the 14th Amendment, passed after the Civil War to chase out of office insurrectionists, Confederate insurrectionists who engaged in insurrection or rebellion during the Civil War. The only way you can disqualify, and there's a case from like 1869 on this from Chief Justice Salmon Chase, is Congress has to pass a federal criminal statute. You have to bring federal criminal charges for insurrection or rebellion. The grand jury has to indict. The jury has to find the defendant guilty with evidence beyond a reasonable doubt, unanimously guilty. The federal judge has to convict under this specific federal criminal statute for insurrection or rebellion, and then that conviction must be upheld on appeal. That is the only way you can disqualify. You can't have partisan judges on a state Supreme Court with an expedited election challenge proceeding where you don't have due process, where you're letting in boatloads of hearsay evidence. You don't have a fair trial, or you especially don't let an unelected non-lawyer judge just decree that there's an insurrection and take someone off the ballot.
The thing in Maine is really, I realize that the Colorado case being appealed to SCOTUS is in its own lane. But the thing in Maine, Dave, is really outrageous. Like some non-lawyer Secretary of State is like, she's appointed, not elected, is like, feels very insurrection-y. Really insurrection-y to me, so he's off. Yeah, he's not going to be able to run for president in Maine. Come on, even you have to see that is fraught with peril.
Well, first off, it's great to be back with you, Megyn, and my friend Mike. I'll say this. Last time I was on, I said that the Supreme Court is going to overturn any ruling that kicks Trump off the ballot. So I'm in agreement that the Supreme Court is going to overturn Colorado and Maine. But I must say that I think what we've seen in Colorado and Maine is exactly how the process is supposed to work, where the states are in charge of administering elections. It's in the Constitution, and they interpret this clause that is somewhat vague in the 14th Amendment that is rarely used. And in Colorado, although Mike will say they're wacky justices, the three justices that dissented, that ruled for Trump, were also appointed by Democrats. But in Maine, it's true, it's not an elected official, but that's state law. That's how it works. And the state law then goes to the U.S. Supreme Court to determine whether it is constitutional. I think the Supreme Court is going to overturn it based on due process grounds. They may latch onto that Chief Justice Salmon Chase's opinion that Mike Davis refers to, although I must add that Salmon Chase reversed himself when it came to the case of Jefferson Davis. When he had to lead the trial of Jefferson Davis, he said that the 14th Amendment was self-executing. So he reversed himself on that. But in the end, I do think the High Court is going to rule that Congress needs to act. You can't have 50 different states acting in 50 different ways, perhaps with partisan bents and going after your political enemies. And so let's have Congress rule. By the way, on that note, Section 5 does give Congress the power to enforce the 14th Amendment, but it does not give Congress the power to exclusively enforce it, which is why states like Maine
You're losing
and Colorado
people.
can do this.
Wait, we're losing people. Let's make it simple, because most people are not studying this clause of the 14th Amendment day to day. But essentially, the argument is that the 14th Amendment has a prohibition against insurrectionists from holding federal office. If you swore an oath to support the Constitution and then you engaged in an insurrection, you can be banned from federal office. And one of the questions that's being raised in this is that clause, as you point out, self-executing? Or do you need, as Mike is saying, Congress to pass a law and more due process for the alleged insurrectionist? Or can it just be like, we can all see you were insurrection-y and it's self-executing, and therefore I don't have to get any official body other than me, the Secretary of State, to say you did it? Well, here's what Trump is arguing before SCOTUS, and I'd love to get your take on this. They say, all right, first of all, they point out that the two-sentence clause in the 14th Amendment says anyone who swore an oath to support the Constitution and then engaged in insurrection cannot hold office unless a 2/3 vote of Congress allows it. That's them saying you got to have Congress. It's not self-executing. Then they argue that this provision is not intended to apply to the presidency. Now, we've heard this from Team Trump and their surrogates before, that this really only applies to lower officials, not to the president. And they say, this is I thought, to me, this was a new one. They say the oath for the presidency, by the way, is not even to, quote, support the Constitution. It is to, quote, preserve, protect, and defend it. Now, we've all heard that on various TV shows, right, where they show you the president swearing in, preserve, protect, and defend the Constitution. It's true the word support is not in there, though, seems like preserving and protecting and defending it would be to support it. They also argue that the presidency is not explicitly mentioned in the amendment, only, quote, an officer of the United States. They say that's a legal term that does not apply to the president. However, when Trump was dealing with the Manhattan DA's office in this, Stormy Daniels hush money case, he argued that this case should be moved to federal court because the president is, quote, an officer of the United States. So he argued something different in the Manhattan trial court than he's arguing to the Supreme Court about whether the president is, quote, an officer of the United States. So let me give you a crack at that one first, Mike, since you're more in the defense of Trump place.
Well, I mean, that's an open question. It hasn't been decided, but there are people, including the Denver District Court judge in this case, this biased Denver District Court judge who, she was judicially biased. She donated to an anti-Trump January 6th PAC to chase Republicans out of office, and then she sat on the anti-Trump January 6th trial to chase Trump out of office. So I don't know how she was able to do that. She said she could be fair, but regardless, even that judge, even that Democrat-appointed judge in Colorado, said that the 14th Amendment does not apply to the President of the United States because he's not an officer of the United States under the 14th Amendment. There are scholars on both sides of that. I would say this, it's an important argument, and maybe the Supreme Court will ultimately have to decide that if the Supreme Court finds that there is an insurrection, finds that Trump incited that insurrection, and finds that the Maine Secretary of State can unilaterally disqualify him, or the Colorado Supreme Court can disqualify him. I don't think the Supreme Court will have to decide that question because they can decide on narrower grounds where they don't have to decide the constitutional question.
Like what? What do you think they're going to say?
Well, I think the Supreme Court could say very easily that, hey, if you want to disqualify, it has to be through a federal criminal statute. And Jack Smith and, January 6th Democrats who spent tens of millions of dollars hunting for evidence of insurrection could not find evidence of insurrection because Jack Smith did not charge Trump with insurrection or rebellion under that federal criminal statute. And think about it this way. January 6th was a lawful protest. that permitted by the National Park Service that devolved into a riot. And how many insurrectionists go unarmed into a nation's capital, walk through velvet ropes, follow police direction, take selfies on the Senate floor, and don't burn down the damn place?
It can't be. He's raising a good point, Dave, about how there's been no finding of insurrection. He hasn't been charged with insurrection by Jack Smith. It's really like a gut feeling. It feels insurrection-y. How can that be enough to ban a presidential candidate from a ballot?
Megyn, the wording of the 14th Amendment does not require a charge or a conviction for insurrection. It's just, did you engage in insurrection or provide aid or comfort to one? And here, Trump, you could make the case that he engaged in insurrection and provided comfort to the insurrectionists, even if no one is ever charged. And that's why it needs to go through the courts. And that's why the Colorado courts were right to at least examine the issue. And I thought they had a pretty well-reasoned 133-page opinion. And in Maine, this is the calculation that they're making. And so I agree with Mike, though, that I don't think you need to go to whether the president is covered under the 14th Amendment to overturn it. I think it's going to be overturned on procedural grounds, on due process grounds. But on the question of whether Trump is covered as president by the 14th Amendment, of course he is. Because can you imagine that the framers of that amendment did not want insurrectionists to be elected to the House, the U.S. Senate? But okay, if you're elected president, no way. So I think that's a loser argument. That's why all 7 justices of the Colorado Supreme Court rejected the district court determination. She was just trying to find a way out, and they rejected that. But I think the bigger issue is procedural due process.
The Supreme Court, I do think, will overturn this decision, and I think it has the potential to be a 9-0 ruling. I don't think it's going to be a 6-3, but at a minimum, it'll be a 6-3. I really think they're going to find a way to get out of saying that he is or is not an insurrectionist. They'll pick a procedural ground. They'll punt. They don't want anything to do with another Bush v. Gore situation. But this isn't their only lane of peril. The people at the U.S. Supreme Court, those 9 justices, they've already taken a case that could have greatly impact one of the big cases against Trump. And this is the one I want to spend most of our time on. And that is, I mistakenly mentioned the word immunity when we were talking about the ballot challenge. The immunity case. The immunity case is very interesting to me on a couple of levels. Basically, we're talking about the January 6th prosecution against him by Tanya Chutkan in Washington, D.C., which is based on she's the judge, it's Jack Smith, the prosecutor, based on his alleged insurrection stuff. And that's the case that has a lot of peril for Trump because she wants a March trial date. She could put him in jail before the election. I mean, he really needs to start getting some wins on the board in that case. And so he's got a couple of avenues. Now, the main avenue right now is to say, I am immune from this entire prosecution because all the stuff you're saying I did while I was president. And in the same way, we don't allow civil lawsuits for the most part against a sitting president for acts he did while he was president. We should not allow criminal charges against somebody who is a sitting president for acts he was doing while the sitting president. It would just lead to chaos in the United States, and he shouldn't allow it. And that case has never been decided by the U.S. Supreme Court. So I think the Supreme Court will have to decide it. And what's happening right now in the immunity case is Judge Chutkan ruled against Trump, saying, you don't have immunity for this nonsense. No, it does not help you here, sir. And Trump was going to appeal this to the D.C. Circuit Court of Appeals. But instead, Jack Smith said, forget it. I don't want to waste time with them. I want Supreme Court to hear it right now. So he, even though he was the winner, he leapfrogged the D.C. Circuit Court of Appeals, went right to Supreme Court and said, hey, please hear this case right now. And the Supreme Court gave him the boot on the forehead and said, get out of here. No, it's not time for you. Like, go back to the D.C. Circuit and follow procedure. That's how things go, no matter how much of a rush you're in, sir. So he did. So now he's bringing that case to the D.C. Circuit Court of Appeals, and the arguments are scheduled for Tuesday, January 9th. I mean, it's happening fast. That's actually going to be really interesting. I can't wait to hear how that goes. So he's going to argue, and Trump's team is going to argue that the president had immunity for everything he's being prosecuted for in the D.C. Trial court. In the meantime, whatever the D.C. Circuit Court rules will be appealed by the loser. And at that point, the Supreme Court will have to decide once again whether it wants to take it now that it's procedurally ripe for the Supreme Court. So that's where I want to start. Forget what the DC Circuit Court does for now. I don't care how it goes. The Supreme Court, it would be the most interesting. So will they take it, or will they find a way to weasel out of taking it and just say, review denied, like we deny review in virtually all cases, we deny review here, and leave it with the DC Circuit? Dave, your thoughts?
I think they're going to deny review, Megyn. I think they're going to defer to the appellate court ruling that's going to come out. That's going to be ruled in an expedited way. In contrast to our last discussion about the 14th Amendment, I think this one is clear-cut as a slam dunk. There is no way that a president gets absolute immunity, because if that were the case, then Joe Biden could arrest Donald Trump, could cancel the election and say, hey, look, I have absolute immunity. See, it's not so funny when the shoe's on the other foot. And that's why I think that the appellate court is going to reject it quickly and outright, and the U.S. Supreme Court's going to say we defer to their ruling, and then it's game on in Washington, D.C.
It's so comfortable, Mike, for the Supreme Court to be like, we didn't do it. It was the DC Circuit. We're busy.
Look, the Supreme Court, if the DC Circuit does not hold that the President of the United States at a baseline level, any president has immunity from criminal prosecution for what that president does in his official capacity as the President of the United States, or in the outer perimeter of his official capacity, which is the Supreme Court precedent for civil immunity, the Supreme Court's going to have to take that case. Because think about it this way. Congress, members of Congress under the speech or debate clause are immune both civilly and criminally for their official conduct, right? Judges are immune civilly and criminally for their official conduct. Right now, presidents are immune civilly. And the reason the courts have not established that presidents are immune criminally is because no president has ever been charged with a crime until the Democrats brought this unprecedented lawfare against President Trump, where they've indicted him now 4 times, right? So the issue is going to be, does the Supreme Court establish at a baseline minimum that the President of the United States is immune from criminal prosecution for his official acts, or the outer perimeter of his official acts, like the other 2 branches of government? They are going to have to decide that case, right? And they can decide that very narrowly that, yes, the President of the United States is immune criminally from prosecution for his official conduct. Because if he's not, think about it this way. President Trump gets back into office. President Trump's orders his attorney general to arrest and prosecute for murder President Obama for the drone strike of 2 American citizens, including a 16-year-old American citizen, an extrajudicial drone strike. Obama did not go to a court. He did not get any order. He just ordered a drone strike under his commander-in-chief power as the President of the United States. Does the president have the power to kill American citizens abroad under his commander-in-chief power? Do the Democrats really want to go down this path where they argue that the President of the United States is not immune criminally for his official acts? Why would the president not be immune criminally, but he's immune civilly? It doesn't make sense.
Okay, but here's the wrinkle. Here's the wrinkle for President Trump. And I'm really interested to hear what you guys think about this. As we said, in the civil lane, it is well established that in virtually all cases, you can't sue the president for acts he was doing while president. We don't want our presidents distracted with this, with very narrow exceptions. But there is a DC Circuit opinion. That's the case. That's the circuit court right above Judge Chutkan. There's a DC Circuit opinion in a civil case that recently came down in the civil lane again. And here's what they said. It was a December 30th opinion, but they were quoting an earlier ruling by themselves. And here's the quote. Whether President Trump's actions involved speech on matters of public concern bears no inherent connection to the essential distinction between official and unofficial acts. This is the critical sentence, quote, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain that office is not an official act of office. So what they're saying there, Dave, is that we see a distinction between President Obama launching a drone strike or Trump taking out Soleimani. And when the guy is acting more not as president, but as candidate for re-election, which is not an official duty of the president.
Exactly. And that's why I think this is a slam dunk. I mean, we don't have a king. We have a president. And if you give him absolute immunity, we're going to have a king. I mean, according to Donald Trump, he cannot be impeached for his conduct. And now he can't be charged after he gets out of office. And we know while he's in office, he cannot be criminally charged because that's the policy of the DOJ. So we'd have a king. And yes, that ruling, I think, says all you need to know, that elections are in the province of the states, not the federal government. It's in the Constitution. The federal government does not run elections, not even federal elections. So it's not up to the president to start digging into whether there was illegality in a state's election. So that's why this case is going to be rejected on presidential immunity grounds. And then the Supreme Court, I think, is not even going to review it.
What about that, Mike? If the court finds, as it did in this, the DC Circuit Court of Appeals, as it did in this case, it just decided that campaigning for re-election or objecting to the procedure that happened in a vote because it didn't benefit you or you think it was unfair as the candidate for re-election, that's not the official duties of a president that would lead to immunity. And so we don't need to even get to any other larger question. All we're going to say is very clearly challenges to the way the vote went down are in your capacity as an individual seeking re-election, not your official presidential responsibilities.
Well, President Trump on January 6th acted in two different capacities. He acted as the president of the United States with the constitutional duty to take care that the laws are executed. That's in his presidential capacity. He also acted as a presidential candidate that day, advocating for the Congress to reject the vote, to not certify the vote. That's in his personal capacity. First of all, it's not illegal to object to presidential elections. And that's where Jack Smith and Democrats are getting this all wrong. It's not illegal to object to presidential elections. It is specifically allowed by the Electoral Count Act of 1887. If it were illegal, Democrats would be in jail for objecting to Republican wins in 1968, 2000, 2004, 2016. We don't see Al Gore and John Kerry and I don't even know who lost, the three Democrats who lost in jail, Hillary Clinton, for losing the presidential election and objecting like they did, right? And so what happened was they objected to the election. That was in his personal capacity. That is allowed by the Electoral Count Act of 1887. It's also allowed by the First Amendment. The riots that occurred, that was in the president's official capacity. The Democrats are alleging that as the president of the United States, he did not stop the riot. They're saying that he did not stop it in time. He did not order the DC National Guard into the Capitol to stop the riot. And as the president of the United States, he's the commander-in-chief. He runs the DC National Guard. Unlike the states where the governors run the National Guard, the president runs the National Guard. So they're saying that he did not send in the National Guard fast enough. Okay, well, can a presidential candidate send in the National Guard, the DC National Guard? Can a private citizen send in the DC National Guard? No, only the president of the United States can send in the National Guard.
So Dave, can you speak to that? Because Mike's first argument was separate and apart from immunity, there was no crime here. There's no crime. He's allowed to challenge the election. Doesn't make him an insurrectionist. But that's a later question. First, we have to get past whether he can be prosecuted at all or whether he has presidential immunity. And his second argument spoke to that. I haven't actually gone back recently to look at Jack Smith's allegations against Trump. He's got 4 claims against him. And I know that at least in the Colorado case, it came up that he not only raised all these challenges, but he also sat by while the riots were happening for too long. Is that part of Jack Smith's case? And do you concede that if that's part of Jack Smith's case, he is challenging for sure Trump's behavior as president while he was sitting in the Oval?
It goes back to what he did, Megyn. He is allowed to object to an election and challenge it. You go through the courts. That's what you do. You could make challenges during the counting of the votes in the Senate. But what you can't do is you can't put up fake electors. You can't call the Secretary of State and say, find me 11,780 votes. You can't encourage people to go to the Capitol and talk to your friends about, hey, it's okay if they're armed, let's take down the magnetometers. That's the kind of thing that Jack Smith is compiling in the whole. Now, if you look at it just in isolation, where Mike is correct in saying, hey, the president has the power to call the guard. Yeah, but Jack Smith's not looking at it in isolation. He's looking at everything and saying he tried to obstruct the counting of the votes. That's a crime. He had a conspiracy to defraud the United States. That's a crime. He tried to deprive people of the rights to get their votes counted. That's a crime. And that's what he's being charged with in D.C.
All right, well, we'll get to that. I want to get back to that in 1 second. You're taking on Mike's first point, which is he did do more than just challenge the vote. He did more. I mean, we have a gut feeling that Trump did more to challenge this vote than we've seen in the past. But this trial will come down to what exactly more was it, and was that conduct illegal? But before we get to that, let's stay on immunity for a second. And Mike's second point, which is, if you're coming after him for not acting quicker as commander in chief the day the riots, broke out, you're coming after him for decisions he made as commander in chief.
If that's all he did, and all he did was he was too slow to call up the guard, he didn't take the threat seriously enough, then I don't think that Jack Smith would have a strong case. But that's not what he's being alleged of doing. It's a lot bigger than that. That's part of this whole scheme.
Okay. All right. I got it. That's a concession. I got it. But that gives us where we need, now we know where we need to argue. And I do want to spend another minute on the allegations that you just laid out, because, you make it sound bad. And listen, and no one here is defending Trump's behavior around January 6th and the election. I'm not defending that. But is it illegal? And does Jack Smith have a crime alleged adequately here? You mentioned the phone call, whatever, to the Georgia Secretary of State. Okay, he's got a defense for that. He's going to take the stand, or somebody's going to say, I thought I had been cheated out of 100,000 votes. I was only saying, look, all you need to find when you're doing your searches and reviewing the votes is 11,000, because that would put me over the edge. You don't have to keep counting after you get to 11,000 and change. That's what we're going to hear. And the speech at the Capitol, he said, be peaceful. Peacefully march, peacefully. He didn't tell anybody to go breach the Capitol or assault police officers. To the contrary, he said remain peaceful. And on the magnetometers, I have heard, for example, I heard Molly Hemingway, who covered Trump on the trail quite a bit for the Federalist during his presidency. And she was saying, you got to understand, Trump, and you guys know this, is obsessed with crowd sizes. He wants crowds. If he's going to give a speech, he wants a lot of numbers there. And he repeatedly said throughout his presidency, get him around the magnetometers. Let him in. The Secret Service takes too long. These are my people. They're not armed. It's fine. So that was a pattern. And I think that they will be able to show it wasn't about Trump trying to get armed insurrectionists on campus so they could storm the Capitol. It was about Trump just saying, no one's here to hurt anybody. Like, stop it. It's taking too long, and I'm going to give my speech, and I want the people in, which changes what you just said, Dave, from something that sounds nefarious and terrible to, oh, that's Trump.
The problem, Megyn, is that when you look at it in totality, when you look at his comments about Mike Pence, for example, sending out that inflammatory tweet that really did enrage people about Mike Pence. And then after this is going on for hours, for having him sit in the White House approvingly of what's going on and not calling off the dogs, when you put it all in totality, that's where it's a crime. If you just look at it in isolation, and that's what Trump's lawyers are going to do, what Mike did, which is to say, hey, as president, he may have made a mistake in not calling the National Guard. Okay, but if you look at it in the context of the reason why he didn't call the Guard was because he wanted that mob to storm the Capitol to obstruct the counting of the votes, and that's the crime.
Go ahead, Mike.
Under that theory, can you charge President Biden with manslaughter for the American troops being killed during the Afghanistan withdrawal? Do you really want to go down this path where if you're saying that the president did not do his job quickly enough, or he was negligent in doing his job, that he can be charged with a crime? There is a reason we have government immunity for judges, for members of Congress, and apparently for presidents, unless it's President Trump, because apparently there's a Trump derangement syndrome exception to every protection for every president.
Okay, now I want to shift to yet another angle that could get this. And the January 6th case, to me, it's huge, because even though the Mar-a-Lago case is the case in which he's probably facing the most actual trouble, I would not be giving Dave this hard a time about the facts alleged against Trump on the Mar-a-Lago case, because if it's true and he defied a federal subpoena, it's no bueno. But sticking with J6, it's it's a very important case because, again, the DC jury is going to hate him. And it appears Judge Chutkan is not his fan. And this is a case that's being fast-tracked and that could wind up in, putting Trump in jail before November. So this is the case we really need to be paying very close attention to, and the one that's going to be affected by this immunity ruling that may stop with the DC Circuit or may go up to SCOTUS, et cetera. And there is another case percolating through the DC Circuit, the federal courts in DC, including the DC Circuit Court of Appeals and now up to SCOTUS, that could wipe out half, at least, of the case against Trump. It's very interesting. And this is a case involving other J6 defendants, not Trump. SCOTUS took the case, so it's going to go up. And they haven't scheduled oral arguments yet, but it's January. The Supreme Court, its term ends in June. So it's going to happen sometimes in the next 6 months. It's going to get decided, and we'll have to wait at the latest till June to find out their ruling. Now, usually in my experience, the trial court, if it's dealing with half of the government's case, could get thrown out because the Supreme Court's about to issue a ruling that 2 of the counts here may not be constitutional. They may not be criminal charges at all that you can bring. You would wait. Most prudent federal district judges would say, I'm not getting ahead of my skis on this. Supreme Court's got it. My docket's full enough. We'll kick this thing to July after I got a ruling from my big bosses on whether half of the government's case is going away. That's not happening so far. Jack Smith wants to go full speed ahead, the prosecutor, and it seems like Judge Chutkan's. So to me, that's just smells of partisanship. What's the rush other than to get him in jail before November? All right, so here's the case. One of the J6 defendants has appealed his conviction or his being charged with this crime under federal statute. They call it 1512, which accuses defendants of obstructing an official proceeding. Now, this was part of the Sarbanes-Oxley Act. You guys know this. I was still practicing law when that thing was passed. And it was passed because of Arthur Anderson, which in connection with Enron got subpoenaed and it was getting investigated by the SEC for being complicit in Enron's crimes and started shredding a bunch of boxes and documents. So they passed this statute saying you obstruct an official proceeding like that, you're going to jail. Well, Jack Smith is trying to use it against Trump, and federal prosecutors are trying to use it against J6 defendants and have been using it successfully against a bunch of J6 defendants, saying, you tried to obstruct an official proceeding. You tried to interfere with Congress doing its duty and voting that day. And it's working. CBS News with a report, the Justice Department has charged more than 327 defendants with this crime, which carries a maximum of 20 years in prison. More than 50 have pleaded guilty. So now you get the one guy who says, you know what, this is a bullshit crime. You can't, this is not a crime. This is for the Arthur Andersons of the world. This isn't for people who get out of control on the Capitol grounds. And CBS interviewing at least one former federal prosecutor, the quote is, the obstruction charge, quote, permeated every major J6 trial in the district court in Washington. He went on to say, this is Gene Rossi. He represented one of the Oath Keepers charged. He said the 1512 charge for these prosecutors has been their gold standard, their North Star. It was the capstone of their prosecutions. And now they are going to decide, this Supreme Court, whether this is, in fact, an appropriate use of 1512, whether you can go after J6 participants for obstructing an official proceeding based on the riot on J6. And if they rule, the lower court ruling said you can, go for it. And Supreme Court took it. They usually don't take it just so they can affirm it, though they sometimes do. So I'd be feeling pretty good if I were a J6 defendant that they're going to say this is not a charge. And it's going to lead to a whole bunch of new trials for the J6 defendants. And it's going to lead to a bunch of lower pleas, easier pleas, lesser pleas between prosecutors and J6 defendants. And it will, if they overturn these convictions and say this is not an appropriate use of it, wipe out the majority of Jack Smith's case against Donald Trump in that Judge Chutkan J6 Washington, D.C. federal trial. long-winded explanation, but it's kind of complicated. So how do you guys see this appeal, which doesn't involve Trump, but will affect him, playing out? And how does it affect the timing of this case, Mike?
Well, I don't think that Biden special counsel Jack Smith or DC Obama Judge Tanya Chutkan are going to be cautious here. They've proven that over and over that their goal is to get Trump. The Biden Justice Department waited 30 months to bring unprecedented charges against a former president who happens to be the leading presidential candidate, and they timed these charges to interfere in the 2024 election, along with these other Democrat prosecutors. They have 4 different criminal indictments against Trump, and they have stacked these trials back to back to back in 2024 to interfere in the election. And so what should happen if you had a reasonable prosecutor and a reasonable judge, they would say, wait a second, we are in uncharted territory here. We're dealing with a presidential election. There is no rush to try this case right now, especially after you waited 30 months. Let's wait until the Supreme Court decides this key issue so we know before we move forward with a trial and conviction in D.C., which is certain in D.C. because his name is Donald Trump, and it's in Washington, D.C. with a jury pool that voted 95% against Donald Trump. And these judges on this D.C. district court are Obama judges like Tanya Chutkan or Trump deranged rhinos. I know this. I helped pick and confirm these people. These are the swamp monsters of the judiciary in D.C., right? So, but what you've seen with Jack Smith in the past, he has horrific judgment, as evidenced by the fact he has been rejected unanimously by the Supreme Court now twice on these political cases. He brought bogus charges against former Virginia Governor Bob McDonnell, a likely 2016 presidential or vice presidential contender. He won a conviction, and it wasn't until after Bob McDonnell's life was ruined and his political career was ruined that the Supreme Court unanimously reversed him. It is very hard to get a criminal conviction reversed by the Supreme Court. It is nearly impossible for that to happen unanimously, but Jack Smith found the way. We talked about he also found the way when he went right to the Supreme Court. He tried to leapfrog the D.C. Circuit to get immunity decided quickly so he could prosecute President Trump before the election. He got rejected unanimously by the Supreme Court. Jack Smith is the Democrats' political Scud missile they bring in to take out Republican presidential contenders. He doesn't care if he ultimately loses. He got banished to The Hague. Joe Biden and Merrick Garland brought him back because he is a clown, a partisan clown you bring in to take out Republican presidential contenders.
You know, Dave, it does feel like we were just over Christmas and I was looking at my kids' toys, and one of the toys is Stretch Armstrong. You pull him, stretches. You know, you could make a good case that he looks a lot like our friend Jack Smith, who's stretching these statutes in the Bob McDonnell case and now in the Trump case to try to fit conduct he finds politically objectionable.
Megyn, in that McDonnell case in Virginia, he won at trial, and then it did get rejected at the Supreme Court. But he wasn't the lawyer at that time. He was not the Solicitor General. So the Solicitor General lost the argument. Jack Smith won his conviction.
I see. It was a crappy appellate lawyer who lost it.
Blame the appellate lawyer. But you know what? I actually, as a prosecutor, I admire Jack Smith. I think he's this guy is going full speed ahead. He doesn't care about politics. And I'm not going to get you the Jack Smith bobblehead doll anymore, Mike, for your birthday. That's going to be crossed off the list. And I'm amazed.
He's going to get you Stretch Armstrong instead.
I'll take Stretch Armstrong, Megyn. I remember Stretch Armstrong. Yeah, absolutely. You know, Hunter Biden, let's talk about him for a sec. Hunter Biden is being charged with a crime. Well, hear me out here. Hunter Biden is being charged with a crime of possessing or applying for a gun.
No. I can't handle Hunter yet. This is a confusing enough segment as alone. Can we just before you comment on him, can you comment on my long wind up about how the January 6th case is probably going away? At least half of it is going to die when SCOTUS decides this J6, the other defendant's case.
I don't think SCOTUS is going to overturn that statute's application in this case. It takes 4 justices to hear a case. I admit I'm surprised they took it up, but I think they're going to do what every other judge has done in this case, except for one Trump-appointed district court judge who found that you can apply 1512 to obstruction of official proceeding in the cases of the rioters. Yes, so I think they're going to affirm it. And as to whether they should wait and stall until the Supreme Court rules, that's where I bring up Hunter Biden. Hunter Biden is charged under a law that has already been overturned as unconstitutional in the Fifth Circuit. It's making its way in the courts, and yet he's still being prosecuted under the gun law. Exactly. So this
You're
is
such a Second Amendment advocate.
Prosecutors. Right? But this is common for prosecutors. We're not going to wait for the Supreme Court to perhaps overturn the statute. We're going to keep going forward like every other judge has done. And I think that the Supreme Court anyways is going to sustain that statute.
If they keep going, when half of the case against Trump might collapse at the hands of SCOTUS, it's not even just the DC Circuit. It's like the Supreme Court might throw out. It just shows to me the partisanship, especially given the stakes and who it is and how they know this is being perceived. All right, stand by because we've got more to do with Mike and Dave, and we're going to squeeze in a quick last break. All right, so let's do some housekeeping on these trials. That March case that we've been talking about is still scheduled for now to start March 4th, the day before Super Tuesday. That's not going to happen because they've got these appeals going up. But the question is, when will it happen? Dave, what do you think the timing of that March trial will actually be?
I think within 60 days of that March date. I think it's because I see the expedited review at the DC Circuit Court of Appeals. They'll come out with an opinion pretty quickly. And then I think the U.S. Supreme Court is going to defer or deny cert on the immunity issue. And then it goes to trial.
And that there'll be no delay as a result of this other J6 case we just talked about.
Right. They're moving full speed ahead. I don't think the Supreme Court is going to rule before then. And I don't think it matters because I think they're going to allow that statute to be used anyways. So yes, I don't think that's going to matter.
And even if Trump wins, or like the J6 defendants wins and Trump's win, and there's still two other counts against him in the J6 case. So, Smith and Chucking can both say, well, that's reason enough to let it go forward. Mike, what do you think? Is there any chance that case gets tried as early as May?
No. And the reason is that the Supreme Court is almost certain, if the DC Circuit doesn't do this, the Supreme Court is almost certainly going to hold that the presidents are immune from criminal prosecution, like members of Congress, like judges. The Supreme Court will have to remand the case back down to Judge Chuck, and she'll have to have an evidentiary hearing on that immunity issue, on what to establish the facts, to figure out where the immunity lies and where it doesn't lie. And you're going to have to do this while Trump has back-to-back trials in other jurisdictions, whether it's the civil fraud trial that's going on now, and the 4 criminal trials. And so I don't know how you can rush this and get this done. Separate from that, there's a lot of discovery, right? So they're just not going to be able to get this done. And you have to ask, Jack Smith waited 30 months to bring these charges. What's the rush other than election interference?
Mm-hmm. We did go back and look under count 1 in the Jack Smith case, conspiracy to defraud the U.S. Jack Smith detailed Trump's actions on J6 and then noted he, quote, repeatedly refused to approve a message directing rioters to leave the Capitol as urged by his most senior advisors. Also noted his 4:17 p.m. video message that day saying the election was stolen, finally asking people to leave, saying they were, quote, very special. So the court could be told to decide whether those were commander-in-chief decisions or those were Trump, the candidate, decisions. But the more Trump can put in the commander-in-chief camp, the more likely he is to get immunity for it. Okay, and so that's the January 6th case. He's also pushing to have that case televised, which federal court trials are not. Is there any chance Judge Chutkan allows that, Dave?
No, unfortunately not. This is one area I agree with Trump. I want these cases televised. There needs to be more transparency in federal court. There's none. And perhaps Chief Justice Roberts can change that, but I don't see that happening anytime soon.
All right. And then very, very quickly before we go, is Trump going to jail before November of 2024? Mike?
Well, if they try to do that, it's going to guarantee you that he's back in the White House, and they're going to have to clear out a cell block and put his Secret Service agents in the jail with him. So that shows you how dangerous these unprecedented indictments of a former president and a leading presidential candidate are.
Dave, yes or no? Is he going to jail before November?
No, I think he'll be convicted, but I do not expect him in an orange jumpsuit before November.
Okay. Thank you, gentlemen. Always a pleasure. Don't forget, we've got Jesse Kelly here tomorrow.